Hi, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today we're going to talk about a landmark case out of New Mexico that resulted in one of the largest medical malpractice verdicts in the history of the United States. So it's very exciting. I got the inside scoop from the attorneys who actually tried the case. So let's go through it. So the brief summary is that back in 2017, a 66-year-old man sought treatment at a clinic in Albuquerque, New Mexico, because he had fatigue and weight loss. Now, little did he know that despite his specific concerns, the doctors and the business people in this specific clinic called NewMale weren't really interested in making him feel better, but they were more concerned with making money, right? And following their business objective. And so they diagnosed him with erectile dysfunction, ED, and then subjected him to unnecessary treatments. Specifically, they gave him invasive penile injections and also supplemented that with testosterone implantation. But let me get into it in more detail so you understand what actually happened, and then I'll tell you the result, including the verdict. So basically, the trial just happened. It ended, I believe, a few days before Thanksgiving in late November. And the trial was being handled by the firm known as TL4J, Trial Lawyers for Justice, that I've talked about before in other videos, and I've actually partnered with them on cases. They're very good attorneys. So basically, the reason it went to trial was because the lowball offer, the final lowball offer from the defendants, was rejected. And then they said, okay, if you're not going to settle for a reasonable amount, then the only choice is to go to trial. And they said, look, it's time to burn the boats because you guys are not willing to settle. And it was a real odyssey, and it resulted in a landmark verdict against NewMale. So it actually started back in 2013. That's when this company was formed, right? NewMale. What happened was two emergency room doctors in Wisconsin started NewMale with two non-medical business guys. Now, one of these non-medical business guys was actually banned from banking and fined $50,000 by the FDIC for breaching fiduciary duties as a former bank president. So he already has a history of fraud, and now he's partnering with these two doctors starting this company. And these four guys went into business and they wrote ads that emphasized that they were experts in men's sexual health. And they also said that they had sales and training materials on how to sell injections. So remember, what does a doctor have to do? A doctor has to help patients, right? Treat conditions. But what they're doing is they're focusing on sales and training material and how to sell injections for what they called penile rehab. And they did it in a package because they could not make money writing prescriptions for generic Viagra or Cialis. And their ads never mentioned injections, so everything was hidden, right? The ads never said anything about injections, but then the owner said testosterone was the gateway to get people into the clinic. So they want to get people in, and then they want to, hard sell them on these injections, these packages, which go up to like $5,000 and are very, very invasive. So once they get you in, right, once the patient comes in, what they do is they say that they're going to give you FDA-approved, 98% effective erectile dysfunction treatments. That's what they claimed. And they said it's going to cure your ED after 6 to 12 months of use. But this was all false because what they were really doing was they were, selling these injections, which are very dangerous. And some of their advertisements, which this particular plaintiff actually didn't see these, but some of this company's advertisements even offered a free test dose to the first 25 callers. And during the trial, a juror actually, because in New Mexico, jurors are allowed to ask questions. So during the trial, the juror actually picked up her hand and she asked the question, is that even legal to give a free test dose of a drug in an advertisement for a doctor? And then the expert who knows about legality, the medical expert said, no, it's not even legal. So they were doing crazy things. Once in the clinic, people would ask for testosterone and they would be offered a test that the company called NewMale So Numel called this test medically necessary to evaluate erectile dysfunction. But internal training and sales material called this test mandatory, and it promptly caused a chemical erection. And this is how Numel got plaintiffs, like this particular injury victim, that's how they got them to have this test injection at the initial consultation. And in 2017, at the client's first visit, he agreed to the test, although he clearly stated the only reason he wanted a little bit of testosterone, such as a cream or a pill, was because he had fatigue and weight loss being 66 years old. He had no problem with sexual health. In fact, on the medical form, he left the entire sexual health blank. He didn't put anything because that wasn't why he was there. And so after inducing an erection by injection and the medicine, Numel would diagnose ED and start hard selling their packages of treatments. And as per the materials, they would tell patients that ED left untreated over time causes irreversible damage, atrophy, fibrosis, literally use it or lose it, like a penis is a bicep muscle. And this is medical fraud because it's not true. Now, this fear-based medical lie fraud induced patients like this particular client to purchase the penile rehab therapy program. And then they sold it for use regardless of sexual activity with an antidote and gave patients both medications to self-eject at home. So the client, 66, disclosed multiple medical conditions to Numel in addition to saying that he was widowed, and they did not care. He testified in trial that the physician's assistant injected him, putting him in a very vulnerable state, and he said it scared the heck out of him when they had diagnosed ED and told him nothing would cause continued irreversible harm, only their medicine would cure it. And then he also said he felt some hope to maybe have a love life again after losing his wife 5 years earlier. And this particular attorney who wrote the description found it heartbreaking, and it was heartbreaking and outrageous that the defendant's lies put him in this unconscionable position. So there is an FDA-approved drug for intracavernosal IC injections that helps men with significant nerve damage achieve erections for sex after prostate surgery, spinal cord injury, or confirmed vascular damage. But Numel lacked the diagnostic tools to measure any of this. And the injections do carry risks. They require extensive dose titration and the patient training by a urologist, and urology guidelines are clear. For ED, the first lines of treatment are therapy and pills, and only those who fail those first two lines, right? You fail therapy, you fail pills, only then, if you have a medical reason and the goal of having sex with a partner, can you be a candidate for these IC injections? So the entire point was first do no harm, but these guys, did not listen to that. What they did was they just, put profits over safety. And even though this particular client, this particular patient never even tried pills for ED, he had no partner, Numel did not care. They taught their staff, contrary to medical evidence, that 98% success rate of their painless injection therapy made it better than pills. And their corporate culture also incorrectly told staff only about 10% of ED cases. They actually said that 10% of ED cases are psychological, but if psychotherapy helps, then they said, and this is like really outrageous, they said, if psychotherapy helps because the ED is psychological, then they said, quote unquote, then the guy is a pussy. They actually said that, and they had slides in their internal training that said that. And when the jurors heard that, this crass and misogynistic training slide, it just shocked the jury. But then instead of, stepping in gum or dog poo, the defense attorneys in the lawsuit, in the trial, inexplicably kept returning to the slide and trying to explain it, which fell flat and seemed to even more loudly demonstrate Numel's culture and the defense lawyers acting just like their clients, shameless, unaccountable, even as they kept pointing blame at the client. So after Numel's physician's assistant injected the plaintiff, diagnosed ED, and prescribed the 3-tier package program of injections and testosterone, their non-medical sales guy followed a bizarre 3-page sales script the non-medical owners wrote in order to close the deal. And it's outrageous, and it was actually attached to this note. But at trial, the sales guy testified Numel was just another sales job. Before, he sold insurance, and after, he now sells HVAC systems. So no medical training, he just sells, he's a salesperson. But it's reckless and negligent, and it's also his job to train men who purchase the injections on how to self-inject the medicine and how to do the antidote at home. So it's really crazy because this guy's not even a doctor, right? He has no medical training. He's not even a nurse. He's not even anything, right? He's just a sales guy. He sells HVAC systems, but it's his job to tell you how to self-inject your penis as an antidote, and then also use this auto injector. And the only way he shows you is he sticks the auto injector on a dummy penis in the office, but he's not, a doctor. So beyond that, he admitted on the stand that 37 pages of consent and information forms that NewMail had the plaintiff initial and sign usually just went into the file. They never gave the client a copy. And they only would give the client a copy if the client specifically asked for them and demanded them. But this is how this particular client ended up with no emergency hotline number or priapism directions to follow. So the client picked up his injection medicine and was trained in its use a week after his initial consult. On the same day, he had testosterone pellets inserted and underwent a bogus platelet-rich plasma procedure NewMail claimed would heal damaged vessels in his penis and increase the size. And all of this was done without a single consent or discharge instruction. NewMail said they signed all they needed from him on day one, and all this went into his chart. Now, 25 days after purchasing the $5,000, King of Kings gold standard treatment package that they sold, at his initial $149 consult, the client returns to NewMail on a Friday afternoon and says he's having trouble with the injections. He was trying to do what they told him to do, but was not getting any result. So instead of helping him or giving him like testosterone cream or pill, the coach or whoever was there, the PA, the physician's assistant, injected him with a 75% stronger dose of medication to induce another erection. And then, contrary to their own policy, they said, go home and show your friends, quote unquote. That's what they told him. No consent was signed, no forms were provided, and the physician's assistant did not reverse the erection with the antidote that our client could not properly self-inject. So humiliated, the client goes home, and he injects antidote multiple times. There's no success, nothing happens. He spends a painful weekend not knowing what to do until Monday at 8:15 when NewMail finally opens again. Nobody tells him that after 6 hours of a priapism, which is a prolonged erection, irreversible tissue damage occurs inside the penis, and then basically when he shows up to NewMail on Monday morning, 60 hours into a priapism, the physician's assistants had to call his supervising doctor, who's running another NewMail clinic, because there's 12 of these clinics all over the country. He's running a clinic in Las Vegas, in Beverly Hills. They have one in Las Vegas too, but he was running one in Beverly Hills. So he asks, what do I do with this guy? And then the doctor, he basically says, tell him to drive himself to the ER, to the emergency room. So the urologist who was called in to help did emergency surgery. And the urologist at the hospital was so mad to see this happen to another NewMail patient, because I guess this has happened before, that he reported the physician's assistant to the medical board, to the state medical board, in a scathing complaint that the board did take action on, and the physician's assistant lost his license. And he actually testified at trial, the doctor from the emergency room, and he said this is abandonment and this is clear malpractice. So NewMail blamed the client for not knowing to go to the ER sooner and for not calling the hotline number on the forms he signed 25 days earlier, which they never gave him, but they put it in their files at their office, but they blamed him for not calling that number. So, and they said it's his fault because he didn't ask for them. But the local urologist testified that another of his patients had called NewMail hotline and got no response. And the plaintiff's attorneys presented evidence that when NewMail hired their physician's assistant, their job description for him promised no call, no after hours, and no emergencies. And it offered bonuses based on sales and the number of procedures done. That was the bottom line. NewMail did not try to have an after-hours on-call program to care for their patients who might get in trouble. They simply offloaded that onto local hospitals and urologists. And after surgery, the client was left completely scarred, non-functional. Their expert was a Dr. Goldstein, a sexual medicine expert with a clinic in San Diego, California, who has published 400 peer-reviewed articles, including the first paper that promoted Viagra's use of Pfizer. He was a warm, compassionate, intelligent expert that the jury had a lot of questions for. In addition to pointing out the fraud and reckless conduct, the medically unsupported claims of NewMail, he examined the clients before and told the jury with clinical detail how incredibly, irreversibly damaged he was by this. The client was irreversibly damaged. And there's still more. Now, NewMale Corp, based in Las Vegas, Nevada, hired the physician's assistant for the Albuquerque clinic in spite of a trail of previous jobs he had gotten in trouble for. This physician's assistant, in his personnel file, had a databank report that he lost a job in the past for taking drugs off a cart in the operating room, in the OR. For example, that's just one of the examples. He was a disaster witness for NewMale, and Nick Rowley was the lawyer who cross-examined him, and he held him to his prior testimony despite this physician's assistant's desire to keep changing it. And he admitted to telling our client to, quote, go home and show your friends, and also to falsifying the client's records after learning about the board complaint lodged against him. He added untrue things about the client that would help him, such as a lie that the client had tried Viagra in the past without success. So this was all fraud. He was changing the records in order to suit, the defendant's argument. And the physician's assistant admitted that all the forms NewMale had new patients sign were put in their file after the initial consult, and no later consents were needed. And after that, when he was at NewMale, they had lots of priapisms, but he could usually take care of them in the office. And after the board complaint, the physician's assistant entered into an order and is no longer practicing. And basically, the physician's assistant's supervising physician in Beverly Hills was legally responsible for his conduct because it was a battery. And the judge agreed and refused to grant a directed verdict on that issue. And because it's not legally, you cannot consent to fraud, and lack of informed consent is a type of battery. So you just don't really see that so often, and don't have to make that legal argument because it doesn't happen so often. So the NewMale Albuquerque was run and managed by two companies that were subsidiaries of NewMale headquarters in Las Vegas. That's the main company. And so the evidence showed that the NewMale Corporation was responsible for all advertisements, staffing, management decisions for all 12 of its clinics nationwide. And the headquarters and the New Mexico companies were essentially owned and operated by the same four individuals, the two ER doctors and the two business people. So at the end of the case, the judge granted the plaintiff's motion to pierce the corporate veil. So each of these 12 companies will be jointly and severally liable for the verdict and judgment because the jury's verdict also found that they were all civil co-conspirators. This firm, the firm that had the case, has been working with Trial Lawyers for Justice since 2019, but this was their first opportunity to try a case together. And she said that Teresa made tactical evidence decisions and took great discovery depositions for use at trial. And then Keith and Nick were a lot of energy in the courtroom and total class acts. And that Nick's jury selection was very masterful. It was actually his 181st jury selection. And the judge gave him more than a day to assure that the plaintiffs got a good and fair and unbiased jury. And the effect of having a jury that trusts their positions will be honored and respected no matter what, helps everyone and carries through the trial. So these jurors, they paid attention, they asked phenomenal questions, they frequently turned to their notebooks, to the exhibit at hand when it came up. They knew where things were going, even as questions were being asked of a witness. And she says that Keith Bruno's opening statement is a testament to how cases can be won in opening. The evidence and testimony he previewed was all confirmed during the trial. And they prepared the client thoroughly, and they protected him from the defense lawyer. And basically, they did an amazing job. In closing, the defense lawyer told the jury to just give the plaintiff $1 million. So Keith started a rebuttal by saying that felt like when grandpa gives a child $5 to go to the store. And then he told a story about growing up in Pennsylvania and having the high school class 3 years behind his ravaged by OxyContin, in order to artfully compare pill mills to NewMale and draw an analogy to the Sackler family that wanted to pay a mere $6 billion of their $13 billion fortune as the cost of continuing to do business as usual, selling OxyContin and killing people who become addicted. So in healthcare, abuses of power for profit are particularly repugnant. Also, it's important to note that in the years of discovery and pretrial motions leading up to the trial, the defense failed to respond to 9 motions by the plaintiff to compel discovery, to obtain. And so because they failed to respond to these motions to compel, it resulted in the plaintiff's ability to get all of the defendant's internal training, marketing, sales, and hiring documents that I've talked about in this video, right? And that was a lot of evidence that they then used against them. And shortly before trial, the plaintiffs challenged the confidential status of all those exhibits, and the defense failed to fight for their confidentiality, so that was waived. And that was fantastic because it allowed the plaintiffs to fulfill their client's desire to prosecute Numel on the facts and evidence that now sees the full light of day. And she says, like, we have an important and humbling power to make our communities better and safer from predatory practices in this way. So the jury deliberated for 3.5 hours and the verdict was unanimous. The foreperson actually told the lawyers that the jury wanted to give the client $1 million a year because they hoped he will live another 30 years. Plus, they wanted him to get back every penny he paid Numel, which was $5,149, that the plaintiff's attorneys didn't even ask for that, but the jury just wanted to give him back that money. So the verdict came in as $37 million in compensatory and $375 million in punitive, for a total of $412 million, which is an amazing verdict. So yeah, so that's basically the case. It's a complicated case, but I think this is the kind of example of when you have egregious conduct, like really terrible, where people are putting profits over safety and doing things using medicine to just make money instead of actually helping people and hurting people, obviously, causing a permanent, lifelong, forever injuries. And that's what happens. And then you have to pay the price for that, right? And these guys stood up, and everything sounds like all the evidence they gathered in discovery, everything was very, very, it went their way, and that was an amazing verdict. So let us know what you think. Please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. All the best. Bye-bye.